In this video, I will be sharing with you the top 7 hacks for defending yourself in a restraining order hearing. My name is Veronica. I am a defense attorney. I am also the creator of a course called DEFEAT the DVRO, the ultimate guide to winning your restraining order hearing and taking back your life. It is a course for respondents, and if you are interested in that, if you've been served with a restraining order and you're thinking maybe you're going to represent yourself, make sure that you check out the link down below. Okay, so let's get into those top 7 hacks for defending yourself in a restraining order hearing. Number 1 is make sure that you understand exactly what the judge is looking for. Okay, this is going to be a stressful situation. You're in a courtroom, you're in front of a judge, maybe you've never done this before. You're supposed to, sort of act as your own lawyer there. And who's your opponent but your ex? And you probably have some words for your ex. You probably have some things to say. But what you're not going to want to do is rehash your whole relationship or get into an argument or get into who is the better spouse, partner, who cheated on who paid for what. That's not what the judge is looking for. What the judge is looking for is for the person who is asking for the restraining order to show the judge by preponderance of the evidence, which basically means 51% likelihood. So if the judge believes 51% that without a restraining order, domestic violence is likely to reoccur, then the judge will grant the restraining order. So again, the judge is going to look at everything that's presented, and if the judge finds the judge is 51% sure that without this restraining order, domestic violence is likely to reoccur, then you, as the respondent, the person who's responding to this restraining order, you lose, the restraining order gets granted, and the person asking for it wins. Make sure you understand exactly what you're supposed to be talking about during the hearing. Number 2, if the judge asks you a question, be sure that you listen to the question very carefully. Ask the judge if you don't understand, and answer the question. I know that sounds kind of crazy, but you're going to have a lot of things going through your head. And as someone who has defended against restraining orders for over 10 years, I've sat in the courtroom waiting for my case to be called, watching respondents and petitioners do the opposite of that. The judge asks a question and you answer something else that does not directly answer the question. The judge notices that. Every attorney at least in the room, we're trained to notice that. If someone does not answer the question that we ask, the judge definitely notices. And the big problem with that is that you end up coming across as evasive. Maybe you just made a mistake, you misunderstood the question, you forgot the question while you were starting to answer it. Feel free to just ask the judge. You can even say, Your Honor, I'm a little bit nervous. I'm sorry. Could you repeat the question again? But above all, make sure that you listen and answer the question. And if the judge is asking the other party a question, you should probably listen carefully there too, because the judge may have some real issues with the evidence or with the story that the other party's putting forward. And that will sort of alert you to what the judge's problems with it may be, and then you can exploit them. Number 3, you do get a chance to ask the other party questions. And in my course, I teach you how to do that. I teach you 4 different styles that you can use. But let's say you haven't taken the course, you don't know, you just don't feel like you are up to asking the other party questions, then don't do it. You don't have to do it. If you cannot do it or you do not want to do it, what you need to do instead is make sure that you give your own statement and address the other party's allegations. Don't miss anything. If they describe some event of domestic abuse, don't just skip over it. Even if nothing like that happened, you can even say, look, Your Honor, I heard petitioner say that XYZ happened. That did not happen. I can't think of any incident that's even close to that he or she could be talking about. I just don't know. Make sure you address every allegation in your own testimony. And let's say that you have proof that the petitioner is lying, that the other party's lying. I teach you in my course how to bring that up when you question them, but another way that you can do it in these hearings is you can also only just bring it up in your own testimony. You can say, Your Honor, I heard the petitioner say XYZ. I have proof with me here today that that's not true. I have text messages, video, whatever, showing that that is not true. And you can go from there. So you can bring it up in your own testimony. Number 4, you want to make sure that you tell your story in chronological order. So you really want to think about this first. You're going to read the restraining order that you were served with. You're going to read what she wrote to get the restraining order in the first place. And when you're thinking about responding, so how it's set up on the forms, in California at least, is that the first thing you'll read is the most recent abuse, and then it will ask about past abuse. But that's not really how humans are, in general, how we expect to hear a story. So I think that it's best to start with the furthest into the past and then go from there. And when I say chronological order and telling your story, I'm not saying tell the story of your whole relationship. No, address the allegations that the petitioner brought up and start with the oldest first. Number 5, do not talk over the judge or the other party. Again, I've seen respondents do this time and again. If you are speaking and the judge starts talking, immediately stop speaking. If the other party starts speaking over you, then you're going to look really good in front of the judge and they'll look really bad if you simply stop speaking and let them continue. And remember, you are the respondent. You're the person being accused of being abusive. So the more you can show the judge that you have self-control and that you are polite and professional, the better. Number 6, you can ask, as the respondent, not as a petitioner, just ask for a continuance if you're not ready. You get one continuance if you want to have one. Now, keep in mind that any orders that are currently in place will remain in effect during that time. But if you're thinking, oh my God, I just got served with this thing, or I procrastinated preparing for this thing, the hearing is tomorrow, the hearing is Monday, I have nothing ready, I don't know what to do, it's okay. Just show up and ask for a continuance and you will get it. But just keep in mind that it could be, maybe you're thinking you just want another week, but it's going to depend on the court schedule. Some courts have very, very heavy calendars, and it could be up to a few months before your case is heard. So if you're not able to see your kids or get in your house, that may not work for you, but it is an option. Number 7 is tell the judge how the restraining order will personally affect you. I don't mean emotionally. I mean if it's going to hurt you with your job and you can specifically explain why, like if you have a professional license. I've represented, for example, doctors where that's really important. If you have security clearance and it's going to be a problem for that, then make sure you bring that up with the judge. Make sure that the judge knows. Some judges, unfortunately, have sort of the attitude of, okay, well, you don't want to contact the petitioner anyway, so what's the problem if I put one of those restraining orders on you? But the problem is that, let's say that you guys don't have any kids together, you didn't live together, it doesn't really matter, she's not asking for any money from you. It will come up on a background check. It's not criminal history, but it shows on your background check that there is a restraining order on you. Now, the TRO, so the initial one before the hearing, that's not going to show up on your background check. Don't worry about that. But if the judge grants one for longer, that will. I hope that you found this video helpful. Again, if you are interested in this, if you do have a restraining order coming up, I very much encourage you to go ahead, click on the link down below, and check out my course. The first class in the course is free, so you can watch it and then decide, okay, is this something that you think will help you?